Good morning to all of you. Happy Holi to all of you. Today we are going to discuss a judgment given by the Honorable High Court of Kolkata regarding consent for sexual intercourse. The Honorable High Court held that consensual sexual intercourse by an aged woman, aged about 26 years, cannot be treated as rape, and as per section 90, you cannot hold that no consent is given. Section 90 clearly says regarding the consent. We will come to that later. Here, please remember, consensual sex by a woman cannot be considered as misconception. This heading you can take it. So you can read the case as Binod. Normally you may be knowing in Calcutta, for V they put B. Binod banik versus State of West Bengal in CRA number 297 by 2016, decided on 24th February 2023 by two judges bench, Justice Joymala Bagchi and Justice Ajay Kumar Gupta. Actually, this relates to crime number 424, section 424 by 2009, which was registered under sections 420, 417, 120B and 323 of the Indian Penal Code. Of course, on a complaint or a private complaint filed by the complainant, because it has become a rape case, I should not disclose the identity of the victim. Right? This relates to crime number 424 by 09 of Nakashipura PS. Nakashipura PS. Right. Now we will go to the allegations. The allegations are that the appellant, that is Binod Banik, he had sexual intercourse or number of times with the victim or with the plaintiff, who was aged about 26 years at that particular point of time. And under the false promise of marriage, he got the so-called sexual connection with her. Right? Ultimately, she became pregnant. He promised to marry, but he did not marry her. Actually, she gave birth to a female child, a girl child, on 18/12/2009. But prior to that itself, when she demanded him to marry her, he beat her, assaulted 323, and knocked her out of the home on 10/7/2009. That is when she was just 5 or 6 months pregnant. Ultimately, she gave birth. He did not marry her. So the efforts made by the elders to effect a compromise. Of course, here he promised to marry her, and once again they both lived as wife and husband, but he did not marry her. As such, she was forced to give the complaint in 2009. Right? The police, basing on the private complaint filed by the victim, they registered a case and they concluded that there was a rape against her. So anyway, he has cheated her under the name of the so-called marriage. Therefore, they filed the charge sheet under section 420, 417, 120B, etc. Of course, when the matter was actually it has come to the court during the stage of trial, the sections was altered to 376 and also 417 of the Indian Penal Code. Finished. It has become a rape case. The trial was conducted. Ultimately, the trial court at Nadia, yes, was convinced with the evidence and ultimately convicted the accused for 10 years and of course fined, something like that. Aggrieved by the conviction, he approached the Honorable High Court of Calcutta, so in the shape of appeal. Here, the arguments better to hear. The state argued that even though there was a compromise between the two families, the accused did not take care of the so-called promise and he went back, even though they lived as wife and husband, but he has driven her away out. And the DNA test was conducted on the girl, which proved that she is the biological daughter of this man. But still, he did not marry her. Therefore, there is a strong case. The defense. The defense stated that no doubt the consent was consensual or the consent was given willingly. So here, for example, for the sake of argument, the defense lawyer stated, for the sake of argument, let us presume that there was sexual intercourse between them. But here the woman, she is a grown-up lady, aged about 26 years, she was living with him. So definitely she had known the consequences. She wanted the physical relationship. So therefore the consent was there as per section 90. So as per section 90 of the Indian Penal Code, when the consent was not by an insane person or if it is by misconception, here you cannot take it as misconception. So they have cited two cases, very famous cases, please remember. Uday versus State of Kerala 2003. Second case, Krishna Prasad Mahato versus State of West Bengal 2004. So basing on these two cases, and the Honorable High Court of Calcutta came to the conclusion that she is a major lady and she knows the consequences. She wanted the physical relationship, therefore the sexual relation between them was consensual. Therefore he is not liable under section 376 or 470 of the Indian Penal Code. So the judgment is reversed in appeal. Very good judgment. It will be useful for the so-called clients who are involved in the so-called sexual relationship, live-in relationship, marriages. So please read the judgment and enrich your legal knowledge. Thank you very much.